All right, good afternoon, ladies and gentlemen. It's very nice to welcome you all here to the CELS Lunchtime seminar. I have the great honour and privilege of introducing to you my dear friend and colleague, John Spencer, who is just a wonderful man. He has been a stalwart of the Cambridge system for quite a long time, and he really is responsible for inventing EU criminal law as a distinct subject in its own right, and recognising way ahead of anybody else just how important EU criminal law was. And he has strong views which have not always attracted the approval of some Eurosceptics, which no doubt he will mention to you. But I hand the floor over to John Spencer, and you're in for a real treat.
Well, thank you, Catherine. It always pleases me so much to be introduced by you because you make me feel so good. The only trouble is I don't know how I can fail to disappoint after that introduction. Well, what is EU criminal law actually about? I'm pleased to see so many people here today because I normally think it's as much of a turn-off to Euro lawyers as it seems to be to criminal lawyers. Criminal lawyers think it's a matter for the EU lawyers, and EU lawyers think it's a matter for the criminal lawyers, and normally nobody ever bothers to go to seminars on it. So I'm very pleased to see anybody, let alone so many people here today. Well, there's a US federal criminal justice system and a US federal criminal code and US federal offences, and when you talk about an EU criminal law, you start thinking about that. But actually that isn't what there is, and what there is really at the moment is just this. A series of organisations which exist to try to encourage cooperation, or in the case of Olaf, try to ensure somebody gets investigated and prosecuted for fraud on EU finances, though they don't do any prosecution themselves. They merely investigate and then hand the files over to member states in the hope that they'll prosecute. And then Europol and Eurojust, which are coordination organisations, one for police and one for public prosecutors. So there's a body of law relating to those. There are a series of instruments encouraging mutual assistance and mutual recognition between the member states in criminal justice matters, of which the best known is the European arrest warrant, the fast-track extradition procedure between European member states. There is a body of instruments attempting to approximate substantive criminal law, typically saying all member states must punish this, that or the other, whatever's been in the headlines lately, and must punish it ferociously with at least this, none of which ever bothers the UK at all because we've already got there first and make it punishable with even worse things than that, so they don't cause us any trouble. And then a very small body of measures trying to approximate aspects of criminal procedure. At present, sort of one and a half of those, really. There was one trying to provide minimum rights for victims a few years ago, and there's now another mini one on certain aspects of defence rights that I'll be talking about later. So that's what there is, really, and that's what the discussions are about. What's the UK's attitude towards EU criminal law? Well, public opinion is certainly hostile and ill-informed. If you ask almost anybody in this country what they know about European criminal justice, they'll automatically start talking about criminal justice in other European states in continental Europe, and they'll tell you they have the inquisitorial system, which is awful. And we have the adversarial system, which is wonderful, and they'll probably go on to tell you that in all the continental systems you're presumed guilty and have to prove your innocence, whereas with us it's the other way round. Everybody seems to think that. And the inquisitorial system is absolutely vile and and we are morally superior because we don't have it. And why is that? Well, it goes back a long way, I think, to the Reformation and to the Papal Inquisition for the oppression of prostitutes. Protestants, among others, there was a book which, together with the Holy Bible, was the must-have book for every devout Protestant family in this country, and it was something called Fox's Book of Martyrs. There we are, maybe we can see it. And that is the front page of my family's copy. My father's family were very devout Protestants. According to my granny, when she was a little girl staying with her grandparents, there were only 2 books she was allowed to read on a Sunday. One was the Bible, King James's Bible, of course, and the other one was Fox's Book of Martyrs. And Fox's Book of Martyrs was a book started under the reign of Bloody Mary to commemorate the putting to death of various Protestant martyrs, saying nothing about the Catholic martyrs who got put to death in the intervals when the book was on the other foot, of course. And it's full of dreadful things about the Inquisition, and in the 19th century edition that we have at home, pictures like that. Sorry, it's a bit small for you. There's this poor innocent woman. There's a horrible inquisitor, no doubt a member of the Church of Rome somewhere around there. Now, pages about the dreadful sufferings of all these people under the Inquisition. And that really deeply affected the psyche in this country towards inquisitorial criminal procedure, which is instantly thought of as in relation to persecution of Protestants. And people write about it in those terms, particularly somebody called Torquil Dick Erickson, who says he is a constitutional lawyer living in Italy. He's somebody without any law degree at all, as far as I know, and he writes things like that, saying there's our adversarial system is wonderful. I wonder if it's actually a size that I can never read any of this out to you. Yes. The Napoleonic system under the inquisitorial method was initiated by the Church of Rome in the Middle Ages. Its purpose, the Holy Inquisition, to stamp out heresy, witchcraft, deviant thoughts, blah, blah, blah. Only Britain failed to adopt this method. Here, under Magna Carta, the law was concerned as an instrument to protect, blah, blah. Napoleon standardized the inquisitorial method in his codes, which his armies imposed, blah, 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 and so on and so forth. And now and again you get something the other way in the press, which is when all of a sudden continental criminal justice and Europe is criticised for being too soft. Like that one, perhaps when you can read that. Brussels bomb pots to scrap life jail. Fury over bid to free killers after 15 years. Which is, of course, when the tabloid press have got hold of another thing, which is something coming from Strasbourg and human rights, of course. So European criminal justice is generally bad news in the popular press and even in the supposedly intelligent press in this country, usually because it's inquisitorial and oppressive, but then arbitrarily at intervals because it's soft and lets wicked people off. And that's the background. Now, I got into European criminal law through being part of something called the Corpus Juris Project. Corpus Juris Project, as a lot of you may know, was a study commissioned by the European Commission to try to think up a system that would be effective for investigating and prosecuting fraud on the community finances. It was then called UCLAF, it's now called OLAF, the European anti-fraud agency, but it didn't have any prosecuting powers. It could merely investigate. And member states tended to be unwilling to prosecute people for detected frauds on community finances. And this was a big concern, and we thought up a scheme under which there should be a European public prosecutor charged with prosecuting offences of this sort, operating according to a uniform code of budgetary fraud offences, prosecutions taking place under a uniform code of procedural rules, which of course would provide what the rights the defence had, as well as what prosecutors had. And this European public prosecutor would be operated from Brussels, but would consist of members of the public prosecution services of each member state who were detached for a period of years to prosecute on these type of cases, running from Brussels instead of under their national public prosecutors. And nobody took any notice really until Mr. Torquil Dick Erickson discovered this and told the Daily Telegraph all about it. And the Daily Telegraph in November 1999 published virtually a whole edition which was an alarmist account of this dreadful proposal, presenting it as a Brussels plot to abolish the common law of criminal procedure and to force us to have the Napoleonic system. And the pages more about it. It was going to mean the abolition of jury trial, and it was going to mean the abolition of habeas corpus, and it was going to mean the repeal of Magna Carta as well. Outcry. And there was a cartoon that appeared in some journal, rather, I never found out which one, illustrating what this was all about. And the Daily Telegraph take on the Corpus Juris project quickly got itself into the psyche of the Conservative Party, and the European Public Prosecutor became the hate figure, Euro hate figure #1 of the Tories. And you read again and again astonishing things in the right-wing press about the threat of a European public prosecutor. And I just Googled around a bit about it this morning, and I found this website. It's called Cranmer. Now, of course, as you may know, Bishop Cranmer was one of the Protestants who got burnt during the Troubles in the 16th century. And then it says, EU Corpus Juris, the nightmare begins. Cranmer has been sent a harrowing account in advance of politician application of continental policing methods. Read this and consider that the fascist philosophy upon which this mode of justice is constructive is soon to be EU-wide, manifest as Corpus Juris. And on, cont. And you read letters in the letterpress columns of the Daily Telegraph about that sometimes. I've got a very fruity one here, but we haven't got time, so I won't read it out to you. The Tories were so anti the Corpus Juris idea and the European public prosecutor that in the European Union bill that almost nobody's heard of, but maybe some of you heard of, this Act of Parliament that was put through by the government earlier this year to make it impossible for us to accede to all sorts of changes in EU law without referenda, puts as on the hate list of things that we can't go near without having a national referendum, a European public prosecutor. That puts me in a distinguished position as an academic. Many academics have thought up ideas which they thought were good and which their governments have rejected. But I think I'm the only person who was party to thinking up an idea that was thought to be so bad the government actually changed the constitution of the country to make it impossible for any future government ever to have it. You may or may not know that there is actually a treaty base for a future European public prosecutor in Article 86 of the TFEU. And subject to this and subject to that and subject to the other, then it would be possible for member states to start one if they wanted to, and some member states vaguely want to, most don't, and nothing much is happening about it, though the European Commission would rather like to have it, and Olaf would very much like to have it, and they're trying to keep the idea alive. Well, what happened after the exposure of the Brussels plot over Corpus Juris? Jack Straw was Home Secretary. Was he Foreign Minister? He was Foreign Minister. And I forgot, he was one another, and then he was Minister of Justice later, as I'll tell you towards the end. And he had the honesty to see there was a real problem with trans-border offences. The existing law made it difficult for any member state to prosecute people where crimes had witnesses or evidence or defendants in other member states. And he and the British government recognised the problem, but they didn't like the Corpus Juris solution, and Straw thought up an alternative solution to the problem, which he sold a European Council, first at Cardiff and then at Tampere, the mutual recognition solution to the problem. Instead of having a new vertical structure with a centralised prosecutor and uniform rules, let's have a system under which each member state recognises, no questions asked, decisions of the criminal courts of the other member states. And this mutual recognition principle became the cornerstone of European criminal justice. It's been quoted from one document after another as being so. And it's a UK idea. Thank Jack Straw for that one. It came about, I think, to the mind of Jack Straw because that's what we have in the UK. We teach English law here, but in fact the UK is 3 different jurisdictions, England and Wales, Scotland and Northern Ireland, and in criminal justice matters we automatically recognise each other's decisions, enforce each other's sentences and send each other's evildoers home and all that, and we thought, transpose that idea into Europe and everything will work fine, won't it? Also, I think another idea behind it was that this is basically what we'd already done throughout the European Union in the matter of civil justice, moved to virtually automatic recognition of decisions and orders in civil justice all years before. And the first fruit of this mutual recognition policy, as you probably know, was the European arrest warrant. Actually the first and virtually the only fruit of it, really. It's the European arrest warrant, that high speed, no questions asked, sending people back when they're wanted for prosecution or to serve sentences in other member states, which has generated a lot of controversy in this country and other countries, but basically works reasonably well, though it's thrown up difficulties. It became intermittently a hate object for the Eurosceptic right, and one of the things Cameron did when he came to power was to order an inquiry into our extradition law, which was published last week, an inquiry led by a retired Lord Justice of Appeal, Lord Justice Scott Baker, a great thick report, and that concludes actually the European arrest warrant works rather well, basically, but some minor changes are needed, rather than that it's absolutely awful. It means sending people off to be tried by the inquisitorial systems, which is what the Tories originally said and why they tried to oppose the legislation by which we gave effect to it. The idea was originally that mutual recognition in the form of automatic extradition to other member states would go in parallel with other measures from the EU trying to raise defence rights to a uniform standard throughout Europe. One of the objections to automatically sending people off to be tried wherever was that wherever mightn't provide very good protections for defendants. Serious concerns, though we don't shout it too loud, particularly with some of the states from the former Soviet bloc. And the idea was that in parallel with the European arrest warrant, there would be EU measures to enhance or at least provide uniform protection for defence rights in criminal proceedings. But the European arrest warrant came first, and instruments to improve and ensure uniform protection of defendants came along rather second. Consultations began in 2003 with the UK saying, great, this is wonderful, we're all for this, raise other people's standards up to ours, the UK is behind it. And there were negotiations about a new framework decision on defence rights. I expect you know, if not I'm going to tell you, the instrument under which EU criminal law, primary instrument on which EU criminal law was made pre-Lisbon, was a framework decision. It was like a directive, but it was in justice and home affairs type areas. The European arrest warrant was a framework decision, and there was work taking place on a framework decision on defence rights. Then it got kiboshed by the UK in 2006, which all of a sudden decided it was against an EU measure protecting defence rights. In those days, framework decisions required unanimity from all member states, so it was enough simply that the UK was opposed to it. But the UK ganged up with the Republic of Ireland. We fought with the Irish for years, but we now gang up with them to be collectively awkward in Europe, except when Ireland wants money apparently. And then We also ganged up with one or two other significant member states, like the Czech Republic, I think, and I can't remember who else, and we had a cabal against it, and as a result, the project of a defence rights framework decision failed in 2006. It had to be abandoned. It couldn't be taken any further. Why? Why this change of policy? Well, I think it was related to what was going on at home at the time, because the Labour government was pursuing a very populist policy in criminal justice, which was increase the powers of the police, and one of the things was stop defendants getting away with it because of legal technicalities. And they just published at the same time that document called Quashing Convictions. It's very pale, I'm afraid, which was a paper designed to virtually abolish the power of the Court of Appeal to quash convictions on grounds of what they called technical irregularities. That means failures of the rules of criminal procedure. And, like, for example, evidence obtained by torture or something like that. They seriously were proposing to greatly curtail the power of the Court of Appeal to set criminal convictions aside in any case where they thought the defendant was actually guilty. And there, probably that's too small to read there, is John Reid, the then Home Secretary, saying, "It may come as a surprise to some that the existing law empowers the Court of Appeal to quash a conviction on purely procedural grounds, blah, blah. Such outcomes are damaging to public confidence in the criminal justice system," and etc. And they were pushing for this at the time, and I think they were afraid that at the same time that they were pushing this forward, there was going to be a headline in the Daily Mail saying, "EU gives English criminals more human rights," probably, and they didn't want to have any part in that. It's funny how those Home Secretaries then all looked just like each other, didn't they? How did he get in there? Well, then, to everybody's surprise, the Lisbon Treaty got ratified, and all of a sudden we were in a new world as regards EU criminal law, with a different legal basis for the making of EU criminal law. No more pillars, as you know, and justice and home affairs and the things that used to be done by framework decisions were all communitarised, and instead the instruments become a range of things that include regulations and directives, and essentially directives replace framework decisions. And they're now made by QMV, by qualified majority voting, subject to a kind of panic button procedure known as the emergency brake, but basically they get made by majority vote instead of everybody having to agree, which was getting impossible as the EU got bigger and bigger. And on what things can they be made? Well, under the Lisbon Treaty, two things basically. Article 82 of the TFEU, approximation of criminal procedure so far as necessary to facilitate mutual recognition. Just note how it's still mutual recognition, the cornerstone of absolutely everything. And Article 82.1 says, judicial cooperation in criminal matters in the Union shall be based on the principle of mutual recognition of judgments and judicial decisions, and shall include the approximation of laws and regulations of the member states referred to in blah blah. And then it says legislation can be made on the mutual admissibility of evidence, rights of individuals in criminal procedure, rights of victims of crime, and certain other things, to the extent necessary to facilitate mutual recognition of judgments. And then there's Article 83, which says there can also be approximation of substantive criminal law on a range of specified topics, laid down in Article 83, with the Council having the possibility of adding others if it can ever find itself unanimous on it. The list of things you'd expect to find: terrorism, human trafficking, drug trafficking, arms trafficking, money laundering, corruption, counterfeiting of means of payment, computer crime, and organised crime. So there is a treaty base also for EU legislation trying to approximate rules of substantive criminal law and levels of penalties in respect of those things. Where is the UK in all this now, given that the UK was so hostile to EU criminal law and so pleased to have the power of veto which it had on framework decisions, and it's now QMV? Well, as you probably know, the UK negotiated a system of labyrinthine opt-outs from bits of the treaties. You have to be a bigger anorak than I am to understand all the details of them, but in broad outline, as regards EU criminal law, the UK opt-outs are these. Protocol 21 opt out of any new criminal justice measures unless we choose to opt in within 3 months of, I say, the balloon going up, the proposal being launched. We've got 3 months to decide whether we opt in which case we take part in the negotiations and on the basis that we're going to put up with whatever comes out of them. Otherwise we're not bound and we stand aside. We have the chance of cringing and going back in afterwards, having opted out if we didn't go in to begin with. Then, actually, surprisingly and unknown to a lot of people, Protocol 36, which is about transitional measures, if we want to, we have 5 years to pull out of the entire pre-Lisbon package of EU criminal law if we give notice. I only read that provision properly last night and was astonished to see how wide it was, but and I couldn't believe it would ever be seriously considered. But I also discovered that a civil servant whom I know, who was working on some other things, has just been transferred to the Cabinet Office to consider the possibility of ever doing this. So they put a very clever person, full-time, thinking about whether we should pull the plug on all these pre-Lisbon things. I bet we don't, but I'm something we can threaten and saber-rattle about if we want to. So that's the position in relation to these things. Well, what have we actually done since the new Lisbon regime in relation to bits of new EU criminal law that's come out? The arrival of the coalition in power came pretty quickly after the Lisbon Treaty coming into force, and the coalition agreed an opportunist policy on EU criminal law. I haven't got the words of it in front of me, but it basically was, well, we'll look at each measure and see what's in it for us. Is there anything in it for me, basically? And if there's anything in it for the UK, we'll go in, and otherwise we'll opt out. And how has that policy been pursued? Interestingly, despite all the rhetoric, particularly from the Tories, about how bad EU criminal law is, the policy's been fairly pragmatic. And we've on the whole opted into things rather than opted out of them. Here's one. Oh, that's more on the transitional provisions. We'll skip over that. The European Investigation Order. European Investigation Order was an idea to replicate the same sort of method as with the European Arrest Warrant, but in respect of orders from courts for the collection of evidence, in particular search warrants. At the moment, we have a system of mutual assistance, mutual legal assistance it's called, in these matters, under which basically one member state, through diplomatic channels, goes to another member state and says, please, could you do us a favour? If you wouldn't mind, when you have time, could you possibly go and look at such and such a piece of evidence? So the other member state has a discretion as to whether to do anything about it, and probably will, hoping that maybe it will want the favour returned another time. And there are no time limits, and sometimes things don't ever get done. And this worries the police and prosecutors, and the idea is to set up this European investigation order when it will be orders, mark, get it done, And concern about this opposition from the Daily Telegraph. That's very small, but it says, Britain's to be spied on by foreign police. That's how it's presented. And they were very sore with Theresa May for agreeing that we would opt into the negotiations on the European investigation order. I know why we did, and it was opportunism, and actually intelligent opportunism, because we knew if we didn't, this thing's likely to happen, and this thing is likely to happen with mandatory orders from other courts that have to be fulfilled in a time limit, and any other member state that's in this package is obviously going to do those first before it deals with our mutual legal assistance request. Please, if you have time. All right, that's on one side, so we'd lose out badly if we weren't in it. Actually, I didn't think we had anything to lose under it and everything to gain, and it seemed to me it was an intelligent decision to go along with this. Though if you look on the State Watch website and other things, you'll see attacks on how anti-libertarian all this is. Then the other big thing that's happening is the roadmap on defence rights. In 2009, under the Swedish presidency, the Swedes resurrected the idea of having a defence rights directive, well, still framework decision it would have been, EU measures to improve defence rights throughout member states, and, astonishingly, the UK had changed position on the matter and was now in favour again, and with the UK's backing, the Commission thought up and the Council approved a thing called the roadmap, which was the idea of a series of EU measures taking protection of defence rights bit by bit instead of having one mega package as was originally thought. And let's do them in this sort of order. Now directive, I'm going to use post-Lisbon speak, on translation and interpretation. A directive on minimum information to people when they're charged and being prosecuted. A measure about making sure people have legal advice, and they thought legal aid later on, if you were lucky, when you're being prosecuted, so you have competent legal advice. A measure on being able to communicate with employers and other people when you've been arrested, so you don't just disappear when you've been arrested. Special safeguards for vulnerable people. And lastly, a green paper to discuss the issue of detention pre-trial. Actually, that's a sore matter from our perspective, because in the UK we do manage to not keep people in prison very long pending trial, and actually a lot shorter than in most continental countries, and we get shocked when people are sent off under European arrest warrants, which is supposed to be an expedited procedure, to then find they spend a year, 2 years in prison before they actually get around to trying them. So we signed up to that, and we were in there with it, and this programme has been continuing. Where has the UK got to with this since? Well, there's one on translation and interpretation, guaranteeing that member states will provide everybody with minimum quantities and quality of translation and interpretation, and the UK is in that one. We've signed up to that one. That one's actually been agreed and happening and is going to come into force in, I've forgotten whether 2012, 2013. Anyway, we're in that one. We were up front with that one. Information. We opted in to the negotiations on that one, which are still continuing. I was involved in some discussions relating to whether we should opt in or not, and certainly there were qualms from certain portions of government about whether the information that we would have to give would be compatible with the traditions of our system, and oh dear, maybe it's not a good idea. But anyway, we opted in, and the negotiations are going on. I think probably being a bit protracted because we're trying to get it our way as well as everybody's trying to get it their way, but it looks as if there's going to be a directive eventually providing for minimum information rights to defendants who are charged. I was at a meeting in Brussels to talk about this when the idea was launched, and there'd been a study of what information you're given by the police in different countries when you're arrested and held pending the next stage. And apparently the UK were the good boys in this, because we provide a very simple, in words of one syllable, noddy language instructions to everybody. Whether that recognises declining education standards, I don't know. But anyway, apparently we do it nicely, whereas in other countries they give them wadges of paper setting out there's articles and articles of their criminal procedure code. I mean, you've got to be pretty stupid to get caught, really, and half of them can't read, so you can understand the problems. Then, where have we got to with legal advice and communication? Well, we're sulking on that one. So we're going to work started on a directive on ensuring you had an effective right to consult a lawyer when you're arrested and to communicate to certain people when you're arrested. And it was announced last week that the UK wasn't going to opt into that one. No, we didn't like that one very much. That didn't mean we were going to never opt in. We were going to keep out on the edge and try and influence the negotiations from outside. Maybe if we like it afterwards we'll opt in, but for the moment, no, we don't like that one very much. The rest, well, there was a Commission green paper on pre-trial detention, a very good green paper on the realities of it and the different periods that people spend in pre-trial detention and the proportions of jail populations in different member states who are pre-trial detainees and so on, with an indication something needs to be done to try to speed things up in some countries and reduce the amount of prison population of people pending trial, and asking whether there is any added value really in EU legislation to try to cheer things on their way. And we've got until the end of November, I think, to put in our official response, and individuals can write in as well. From what I've heard, I am pretty sure our government's response is going to be no thanks, we don't want legislation on that. No, we should encourage each other to follow one another's best practice. Let's try to export best practice. I think that's probably what's going to happen. I think it's most unlikely the UK is going to say, great, let's have a directive in all that. So that's where we are on defence rights. And some concluding thoughts on the subject. On these defence rights, the UK actually has the high moral ground, really, because these rights are to do with the early stages of criminal procedure. Whatever faults our system of criminal procedure may have, they're mainly in the later stages, and when it comes to people's treatment by the police and people's treatment pre-trial, what we do now is pretty good compared with what happens in many other countries. It used to be much worse. And hence we had scandals like the Birmingham 6, but we cleaned things up big time with the Police and Criminal Evidence Act 1984, which requires all sorts of basic and sensible things like minimum fixed periods during which the police can detain for questioning, requirement of automatic access to legal advice and presence of a lawyer during police questioning if you want it, and automatic tape recording of police interviews with suspects. Very sensible. And a lot of other countries don't have that. But they should have it. It seems to me it's a very obvious precaution. Similarly, though we're always castigating ourselves in this country about how long proceedings take to get through the courts, we do actually get on with the preliminary stage quite fast and manage to deal with cases quicker than in a great many other countries. And it's a good thing that should be so. And I think it's a shame that we're hesitating and sulking over the Legal Advice and Communications Directive and probably going to backpedal on the others, because what we should really be doing is not saying, oh, European influence, European justice, whatever with that. We should actually be being proud and saying, look, we've got something to give you here. We can teach you something. Yes, we're in here, and then try and work it our way. That would be the sensible thing. Is there room for hope on all this? Well, I think there's some, because there's been a reform in the way that EU policy on EU criminal law is, the UK policy on EU criminal law is actually formulated. Because originally it was in the hands of the Home Office. And if the the Home Secretary at the time wasn't interested in Europe, as many of them weren't, Jack Straw was, but most of them weren't, it meant the civil servants of the Home Office, who tended to have a very bunker-type attitude in all this. And it all circulated around that man, who was a powerful civil servant in the Home Office at the time, who was very Eurosceptic, and was certainly behind or involved in our change of policy and opposing the proposed directive on defence rights. He was a bumptious man, and he got taken apart by the Sunday Express there for having tried to use his influence in his hometown to shut down a pop festival, even though his son was playing in it. That's good, his son was playing in it. Not long after that, Jack Straw found out about him and moved him, and he's now taken early retirement, I'm glad to say. There's all the dirt about him from the locals who say how much they dislike this man. And once he'd gone, and then Reformation and the Ministry of Justice is formed, and the Ministry of Justice takes over from the Home Office quite a lot of EU criminal law policy. The Home Office still does the mutual cooperation stuff, but it's people with a more outward-looking approach. And all of a sudden, both the Home Office people and the Ministry of Justice people have said to the world in general, we want to consult with everybody in this country and we want help on all this, please. And there are consultation groups like there have been on civil justice matters for years. And I'm proud to say that CELS helped in that direction, because we hosted a meeting which was at the initiative of Lord Justice Thomas, a hyperactive Lord Justice of Appeal, who decided the UK should try to have an intelligible policy on EU criminal law matters, at which we brought together civil servants from different government departments who I think had been previously unaware of one another's existence, and the result was a general consultation group which meets under the chairmanship of Lord Justice Thomas from time to time in order to hear what's happening and all these different EU initiatives, and for people from the Crown Prosecution Service and the Home Office, the Ministry of Justice and the Judiciary, and, would you believe it, academics as well, to go along and share ideas. So I do think there is at least the possibility of an intelligent policy emerging. In the end, of course, it's down to what the ministers actually want in any case, and they make the decisions, but the ministers are powerfully influenced by the civil servants, and on the whole, our civil servants are good and intelligent people, and I'm glad that they are now engaging with the academic community, and I hope there might be a more sensible policy in the future. Thank you.